Okay. You know that feeling when you stumble onto a story and it just sounds so completely wild, almost like fiction, but then you dig a little deeper and you realize it actually changed the fundamental rules of the game for, well, for an entire profession.
Mm,
This is absolutely one of those stories. We're diving deep into a case that, believe it or not, started with a seemingly innocent shipping container full of canned tomatoes.
right, canned tomatoes. But it ended up totally reshaping the landscape of criminal sentencing right across Australia.
Hmm.
And crucially, it delivered this incredibly stark warning to anyone thinking about stepping into a courtroom as a barrister.
You absolutely need to hear this if you're navigating or, planning to navigate the complex world of criminal justice. It's got all the elements of a true crime saga, huge stakes, dramatic characters.
But the real drama, arguably, unfolds in the legal battles that came after the crime, a fight that went all the way up to the High Court.
So let's set the scene. That shipping container. It arrives in Melbourne, June 2007, on the manifest. Italian canned tomatoes. Pretty standard stuff. But hidden inside those tins, customs officers made a discovery that just blew everyone away. Made headlines literally around the world.
Yeah, get this. 15 million pills of ecstasy, MDMA.
15 million. That's over 1.4 tons of MDMA, the street value. Estimated somewhere up to $440 million.
At the time, it was the single largest ecstasy haul in Australian history. Just a staggering, staggering amount.
Simply unprecedented scale, as you say. And the figures behind this, well, this incredibly audacious crime, they weren't exactly who you might picture running a global drug ring.
No, not Scarface types, really. There were two men, actually farmers, from Griffith, New South Wales, Pasquale, Barbaro, and Saverio, Zirilli.
Farmers playing for stakes that are almost unimaginable, hundreds of millions of dollars. And inevitably, the law caught up with them decisively.
Right. But as you mentioned, this deep dive isn't just about the bust, as dramatic as that was. It's really about the extraordinary legal fight that followed their arrest.
Exactly. A fight that climbed all the levels of the court system, right to the highest court in the land, the High Court of Australia. And the outcome fundamentally impacted how judges and lawyers talk about, well, the most critical stage of any criminal case, sentencing.
So our mission here in this deep dive is to unpack this really significant case. It's known legally as Barbaro v. the Queen, Zirilli v. the Queen. We're going to guide you through the sources we've looked at, tracing the story from the criminal plot itself to the really tense court battles at multiple levels. And most importantly, we'll pull out what this whole saga teaches us about that delicate balance, that dance between plea negotiations and the judge's ultimate kind of solitary role in handing down punishment.
Yeah, and it's a crucial lesson for anyone involved in the legal system, but we're framing this especially for you if you're an aspiring barrister because the implications are just so direct.
Absolutely. So let's start with the players. The dramatis personae, as they say, and the sheer audacity of their operation.
Okay, at the very center, you have Pasquale Pat Barbaro. The sources paint this really fascinating picture. By day, he's like a respected 50-year-old citrus farmer from Griffith. Seems embedded in his community.
Right, that's the surface. But the flip side, according to the prosecution case and the sources, was this incredibly cunning figure operating right at the very pinnacle of the Australian underworld drug trade.
There are mentions, sort of whispers, of his ties to Ndrangheta-linked clans. That suggests, maybe a deep, perhaps even generational connection to really sophisticated, organized crime networks that operate way beyond rural New South Wales.
Yeah, and the Crown didn't mince words. They identified him as the absolute mastermind within Australia. The term they used was at the apex of the criminal group operating within Australia.
Wow, apex.
He wasn't just involved. He was described as the driving force, the controller, the decision maker, the person giving the instructions. Unequivocally, he was the boss.
Okay, and his key lieutenant, his right-hand man.
That was Saverio Sam Zirilli, also a farmer, a bit older, 55 at the time. The sources describe his relationship to Barbaro exactly like that. Barbaro's trusted lieutenant, his right-hand man.
So important, but maybe not the ultimate boss.
Exactly. The judge accepted his role was substantial, definitely crucial, but ultimately deemed somewhat less than Barbaro's in the overall hierarchy. Zirilli was vital for coordinating the logistics, the movement, the handling of the drugs once they hit Australian soil. And what's really interesting here, particularly for you thinking about legal culpability, is that even though Zirilli was technically lowered down the ladder, his importance was, in a way, elevated in the eyes of the law. Why? because of his close, long-standing, and trusted association with Barbaro.
Right, this wasn't just some hired muscle.
No, exactly. This was a relationship apparently built on years of trust, which becomes highly relevant when you're assessing just how culpable someone is in an organized crime setup like this.
Okay, so the core of their operation, the big one that brought it all crashing down, was that incredible MDMA shipment in June 2007.
Yeah, the 15 million pills, over 1.4 tons, all meticulously hidden inside those ordinary-looking tomato tins.
It wasn't just a big bust. It was, as we said, record-breaking at the time. Really highlights the truly extraordinary scale of their ambition and their reach, presumably international connections.
Definitely international. And here's where their, well, you could call it sheer greed, or maybe just massive overconfidence, becomes really apparent.
How so?
Even after customs officers intercepted that initial massive haul, which must have been a devastating blow to their network, financially and logistically.
You think so?
Barbaro's criminal activities didn't stop. The sources tell us that over the next year, showing incredible persistence despite that huge loss, he was involved in trafficking another 1.2 million ecstasy pills onto the Australian market.
Wow. So they lose potentially hundreds of millions, and they just keep going.
Seems like it. Either determined to recoup their losses or perhaps just maintain their ongoing operation and cash flow. It's hard to say for sure, but the persistence is notable.
Unbelievable. And they weren't just sticking to ecstasy either, right?
No. By mid-2008, they had already set up their next major import venture, this time branching out into cocaine.
Right.
A big shipment, too. 99.9 kilograms of cocaine. The sources suggest a potential street value around $40 million.
$40 million. And the cost to import.
Get this. The sources say the imported cost was just $600,000.
Wow. That just gives you a chilling sense of the astronomical profit margins they were chasing. The markup is insane.
Absolutely. But again, the authorities were onto them. The Australian Federal Police, using sophisticated surveillance techniques, managed to find and seize that cocaine shipment in July 2008.
Before Barbaro and Zirilli could even get their hands on it.
Correct. Before they could take possession. The net was definitely closing in.
So their brief, but obviously incredibly lucrative and dangerous reign at the very top of the Australian drug trade, it comes to a definitive end when?
August 8, 2008. That's the date Pasquale, Barbaro, and Saverio Zirilli were arrested. The criminal enterprise was over.
But, as we keep saying, the legal story, the one that would ultimately reshape Australian sentencing law, that was really just beginning.
Precisely. Which brings us to the next critical phase. The charges they faced, and crucially, the plea negotiations that unfolded in the years following their arrest.
Okay, so they were eventually indicted in the Supreme Court of Victoria. And these were Commonwealth offenses, right? Not state charges.
Yes, that's important. 3 principal counts under Commonwealth law. And because they were Commonwealth drug offenses involving huge quantities, they carried incredibly severe maximum penalties.
Which were?
Life imprisonment for each of the 3 main counts.
Okay, so let's just be crystal clear on those 3 counts. Count 1.
Conspiracy to traffic a commercial quantity of MDMA. That covered the initial massive 15 million pill haul in the tomato tins.
Got it. Can't, yeah.
Trafficking a commercial quantity of MDMA. That related to the 1.2 million pills they trafficked after the first big bust, the ongoing operation.
Right, and count 3.
Attempting to possess a commercial quantity of cocaine that was the 99.9 kilogram shipment intercepted before they could collect it.
Okay. Life imprisonment maximum for each. Huge stakes.
Absolutely. And beyond these 3 principal counts, the sources also mention they asked the court to take into account 3 further admitted Commonwealth offenses.
Right. This happens sometimes under Section 16BA of the Commonwealth Crimes Act.
Exactly. These additional offenses weren't separately sentenced, but admitting them was relevant. It helps paint the overall picture of their criminality, and it could potentially influence the judge's view on things like remorse or their prospects for rehabilitation.
And what were these additional admitted offenses?
They included conspiracy to import a border-controlled precursor specifically, pseudoephedrine, shows involvement in the supply chain, not just the end product.
Okay.
They also admitted dealing with over $1 million in proceeds of crime. And relatedly, receiving, possessing, or disposing of money suspected to be proceeds of crime.
So serious money laundering underpinning the drug ventures.
Definitely points to a sophisticated financial side to the operation. And the sources highlight that these additional offenses, particularly the financial ones, were seen by the judge as a most material point of difference for Barbaro compared to Zirilli.
Why that?
Well, Barbaro's deeper involvement in these complex financial crimes just underscored his high-level role, his deep entrenchment in the whole enterprise. The judge noted she wouldn't punish them separately for these, but they absolutely could and did inform the court about, well, the genuineness of any claimed remorse and certainly their prospects for rehabilitation.
Yeah.
Dealing with over $1 million in dirty money speaks volumes about someone's mindset, doesn't it?
Yeah, it really does. Okay, now let's get to the plea negotiations. This is where things start to get really legally interesting and, frankly, quite contentious.
Absolutely pivotal for the case that followed. These tense discussions happened in late 2011, quite a few years after their arrest. And the starting point was that the prosecution's evidence against them was, well, the sources just say it was overwhelming.
What kind of evidence are we talking about?
Think about it, a mountain of stuff. Extensive surveillance footage tracking their movements, their meetings, phone intercepts capturing incriminating conversations, and, critically, testimony from co-accused individuals who had, decided to cooperate with the authorities to roll over.
So they were pretty much caught red-handed on multiple fronts.
Essentially, yes.
Yeah.
With such a strong case against them, pleading guilty really offered the main, perhaps only, avenue for some leniency, some mitigation on sentence.
And this is where the story takes that critical turn, the one that becomes this foundational cautionary tale for you as an aspiring barrister about how plea deals work, or sometimes how they don't work out as expected.
Exactly. The Commonwealth Director of Public Prosecutions, the CDPP, made a formal plea offer to the defense teams. And a key document here, mentioned in the sources, is a letter. It's from the prosecutor, Mrs. Jan McAlpine, dated October 10, 2011, and then confirmed again on November 3, 2011.
Why was this letter so pivotal?
Because, crucially, it specified an appropriate sentencing range for each accused.
Whoa, okay. So the prosecution actually put a range of numbers in writing as part of the plea offer.
Yes. And this wasn't just like an off-the-cuff suggestion. It was understood by the defense, certainly, as a really crucial part of the proposed plea deal.
What were the numbers? Do we know?
For Pasquale Barbaro, the letter indicated an overall head sentence range of 32 to 37 years imprisonment, and attached to that, a non-parole period range of 24 to 28 years.
Okay, still very heavy, but presumably less than life with maybe no parole.
Exactly. And for Saverio Zirilli, while the sources don't quote his specific range in full, they confirm a comparable range was nominated in that same letter. The Court of Appeal later noted his sort of theoretical starting point, pre-discount, might have been around 30 years with a 24-year non-parole period. And so the range offered to him was lower than that, implicitly acknowledging the value of his plea.
Right, so the defense teams representing both Barbaro and Zirilli, they saw these figures and they thought.
They understood. These weren't just numbers plucked from thin air. They were the result of careful charge bargaining. Maybe dropping some potential charges, and definitely an implicit recognition of the significant utilitarian value of getting guilty pleas. It saved the prosecution a massive, complex, expensive trial.
So they saw this range as effectively
as a joint submission on sentence range, or at least an indication that the prosecution would submit this range to the judge. They absolutely relied on this assurance, this understanding.
And this reliance was central to their decision to plead guilty.
Absolutely central, according to the arguments made later, trusting that this agreed-upon range, hammered out through negotiation, would be put before the court and, crucially, taken into serious consideration by the judge. Barbaro and Zirilli formally pleaded guilty.
When did they plead?
December 1, 2011. They pleaded guilty to all three principal counts. They walked into court for sentencing, expecting, reasonably or not, to be sentenced somewhere within that range specified in the CDPP's letter.
And this is the moment that sets up the whole conflict, isn't it? The expectation versus the reality.
Precisely. This expectation built on that letter is what collided head-on with judicial independence in the courtroom, ultimately leading to this landmark case that rewrote the rules on sentencing practice in Australia.
So the sentencing hearing itself, where did it take place? Who was the judge?
The venue was the Supreme Court of Victoria, and the presiding judge was Justice Betty King.
Justice King. What do the sources say about her?
They describe her as an incredibly experienced criminal judge, well-versed in handling major, complex cases, particularly those involving organized crime. And she had a formidable reputation for toughness.
Okay, so not someone likely to be easily swayed.
Definitely not. Everyone involved, the lawyers, the accused, knew this was going to be a serious, high-stakes hearing in her court.
And the legal teams presenting the cases at sentencing, who was involved?
Experienced counsel on all sides. For the Crown, the prosecutor for the CDPP was Mr. Brendan Young. Representing Pasquale Barbaro, the lead counsel, senior counsel, was Philip G. Priest, QC, a very well-regarded silk. Working alongside him was junior counsel Theo Casamatis. and they were instructed by the solicitors Theo Magassis and Associates.
Got it. And for Saverio Zirilli?
His team was led by Michael Croucher, SC, as senior counsel, with F. Todd appearing as junior counsel. They were instructed by the firm Aquaro & Co.
And you mentioned F. Todd, Frances Todd, stayed involved throughout the appeals.
Yes, she did. And just as a somber side note, the instructing solicitor for Zirilli, Giuseppe Joe Aguaro, the principal of Aquaro & Co., was actually tragically killed in an unrelated incident several years after these events. Adds a layer to the background.
Right. Okay, so everyone's in court. The hearing starts. What happens?
The core conflict, the central issue of the entire case, emerged almost immediately. The defense teams, acting on their understanding from the plea negotiations, attempted to rely on and formally put before Justice King the sentencing range that had been specified in that CDPP letter.
They tried to tell the judge, look, the prosecution suggested this range.
Essentially, yes. They wanted to make submissions based on it. And the judge's response was swift, decisive, and utterly unequivocal.
What did she do?
Justice King declined to entertain a submission from the Crown on sentencing range. Full stop.
She just shut it down.
Completely. The sources report her saying very clearly and directly from the bench something like, I am not allowing submissions from anyone on numerical sentencing ranges.
Wow. Okay, now this is a critical moment, isn't it? Especially for you, listening as an aspiring barrister. What do you do? The judge, the ultimate decision maker, just completely blocked a key part of your planned submission. A submission your client relied on when pleading guilty.
It's a nightmare scenario, professionally. Yeah. Counsel for Barbaro, referred to as Mr. Dunn or Mr. Odgers in later transcripts.
Right. Stephen Odgers, SC, took over later.
Yes. He respected the judge's direction. He didn't press the issue of the range submission in court at that time.
Okay. But Zirilli's counsel, Michael Croucher, SC.
Mr. Croucher, or Mr. Carter, as he's sometimes referred to later.
L.C. Carter took over for the High Court appeal.
Right. He reportedly did not obey the instruction immediately. He actually attempted to provide the Crown's proposed range for Zirilli, despite the judge's very clear indication she wouldn't hear it.
And how did Justice King react to that?
She remained absolutely firm. She indicated clearly that even if she was somehow informed of the range, she would not take it into account in her sentencing determination. It was simply not relevant to her task, in her view.
So the door on the range submission was slammed shut. Irrevocably.
Absolutely. So with that avenue completely blocked by judicial direction, the sentencing hearing had to focus on the other, more traditional factors relevant to sentencing.
What did the defense argue then, without the range?
Well, they argued for leniency based on their client's guilty pleas, stressing the utilitarian value, saving the court a long, complex trial. They also raised the possibility of future cooperation with authorities, although the judge seemed pretty skeptical about that based on the reports.
Okay. What else?
They highlighted personal circumstances, naturally. Their clients' ages, Barbaro was 50, Zirilli 55 at the time of sentence. They argued that any lengthy sentences would be crushing.
Meaning?
Meaning they'd offer little to no realistic prospect of release within their natural lifespans. An argument about hope, essentially. They also pointed to prospects of rehabilitation, though perhaps weakly given the scale of offending. And for Zirilli specifically, they raised the delay in the case getting to sentence and his lack of significant prior convictions as factors warranting a lesser penalty compared to Barbaro.
Standard mitigation points, basically. And the Crown, what was their position now that the range wasn't being discussed?
The Crown forcefully argued for extremely heavy sentences. They hammered home the extraordinary seriousness and the unprecedented scale of the offenses. They kept reminding the court this was, at the time, the world's biggest ecstasy seizure.
They emphasized Barbaro's role.
Absolutely. Barbaro was the apex, the undisputed leader in Australia. Zirilli, his crucial right-hand man. They stressed the international nature of the operation, the meticulous planning involved, and that astonishing persistence continuing the trafficking even after the first massive bust. They painted a picture of sophisticated, determined, high-level, organized crime.
Was there much discussion about remorse? That often comes up.
Yes, and it was a notable point of contention. Justice King expressed her view quite pointedly. She stated she found a lack of real or true remorse from either man.
Ouch.
Yeah, she commented there was, in her view, nothing helpful at all presented by the accused beyond the mere fact they'd pleaded guilty. She directly questioned whether that plea genuinely indicated remorse for their actions or if it was just a pragmatic, self-interested response to the very strong evidence that had basically cornered them.
And the defense argument on remorse.
As you'd expect, they argued strongly the guilty plea was itself significant evidence of remorse. that it was a crucial mitigating factor that should be given substantial weight in lowering the sentence. This fundamental disagreement, how do you interpret a guilty plea in terms of remorse, would actually be scrutinized all the way up to the High Court, particularly for Zirilli.
What about motive? Did the judge comment on that?
Yes, her view was stark and simple. Pure greed. The potential for profits of astronomical order. Given the sheer volume and value of the drugs involved, it was hard to argue otherwise, really.
So the arguments are made, the judge has heard everything except the range, then comes the moment of judgment.
Yes, Justice King handed down her sentences. And true to her reputation for toughness, they were incredibly severe. And critically for the defense and their clients, they were far, far outside the range they had believed or hoped was on the table based on that CDPP letter.
What were the sentences?
For Pasquale Barbaro, on the main conspiracy count relating to the 15 million pills, the sentence was a total effective sentence of life imprisonment. Life. And the non-parole period, the minimum time he must serve before being eligible for parole, was set at a staggering 30 years.
30 years before even being considered for release. He was 50. That's effectively a life sentence in real terms for most people.
It's certainly what the defense would argue was a crushing sentence.
Yeah.
And for Saverio Zirilli, his total effective sentence was 26 years imprisonment, and his non-parole period was set at 18 years.
Still incredibly long terms.
Very significant sentences,
Yeah.
reflecting his role, though less than Barbaro's.
How did Justice King justify imposing such, crushing penalties, especially Barbaro's life sentence?
Her reasoning, as detailed in the sentencing remarks cited in the sources, was clear and unyielding. She found that Barbaro's conduct represented the worst kind of offending. Conduct that, in her view, fully justified the maximum penalty available under the law, life imprisonment.
So the scale of the crime was the key.
Absolutely. She justified the harsh penalties by repeatedly stressing the unprecedented scale and gravity of the crimes. She used the phrase that they were playing for the highest stakes imaginable in the criminal underworld.
Did she address that crushing sentence argument the defense made about their ages?
She did, directly.
Yeah.
Citing relevant case law, she essentially stated that for certain egregious crimes, and this clearly qualified in her view, offenders had, by their own actions, forfeited any right to leniency. They'd forfeited any expectation of release within a time frame that might allow them a meaningful period of liberty in their later years.
Wow. Strong word.
Very strong. And for Barbaro specifically, her reasoning for setting the non-parole period at 30 years was incredibly pointed and quite chilling.
What did she say?
She explicitly stated, according to the sources, that she would have given no non-parole period but for the plea of guilty, meaning life would have meant life, incarceration until death. She strongly implied that, in her judicial assessment, Barbaro's crime warranted absolute life imprisonment, and that only the utilitarian value to the justice system of his guilty plea avoiding that massive trial spared him from that ultimate outcome, allowing for the possibility of parole, but only after 3 long decades.
That really underscores how seriously she viewed his culpability.
Absolutely. It frames the guilty plea purely as a pragmatic discount, not necessarily reflecting genuine remorse in her eyes.
So these sentences, particularly Barbaro's life term with 30 years non-parole, were, as expected, significantly higher than the range the defense thought the Crown had indicated.
Massively higher,
Yeah.
which inevitably set the stage for appeals. They weren't going to accept this without a fight.
The first stop for that fight would be the Victorian Court of Appeal, right?
Correct. The case went before a panel of 3 justices there, Maxwell P., the president of the court, Justice Harper, and Acting Justice of Appeal T. Forrest.
And the legal teams. Any changes from the sentencing hearing?
Some continuity. Philip Priest QC, who had been senior counsel for Barbaro at the sentencing, appeared again for him in the Court of Appeal.
Okay.
And Matthew Croucher SC, who had been Zirilli's senior counsel at sentencing, appeared for Zirilli again. And as we noted, F. Todd, Francis Todd, continued as junior counsel for Zirilli throughout this appeal stage as well.
So what were their main arguments on appeal? What grounds did they raise?
They raised 2 primary grounds, essentially challenging Justice King's approach from different angles. First, and most critically perhaps, was procedural fairness.
The range issue again?
Exactly. They argued that Justice King's flat refusal to even hear the Crown's agreed sentencing range submission denied their clients procedural fairness. They argued it violated a legitimate expectation that had arisen directly from that plea deal letter. They felt they'd pleaded guilty relying on that range being presented and considered.
Makes sense from their perspective. What was the second ground?
Manifest excess crushing sentence. They argued the sentences themselves were just too high, either manifestly excessive, meaning so far outside the proper range of judicial discretion that it amounted to a legal error, or simply crushing, given their ages, Barbaro 50, Zirilli 55. They argued the sentences offered little to no realistic hope of release during their natural lifespans, repeating the arguments Justice King had rejected.
And Zirilli's team also had the remorse point still.
Yes, they maintained that the judge had made an error in her assessment of his remorse, particularly in light of his guilty plea.
Okay. So how did the Court of Appeal rule?
On November 30th, 2012, they delivered a unanimous judgment. And the outcome was clear and deeply disappointing for Barbaro and Zirilli. The Court of Appeal refused leave to appeal for both of them.
Refused leave. What does that mean exactly?
It means they didn't even grant permission for a full appeal hearing. They looked at the initial applications, the grounds raised, and decided they lacked sufficient merit or prospect of success to even proceed to a full argument. A significant hurdle failed at the first step.
Wow. So they didn't even get to fully argue the appeal. Why did the court reject the grounds so decisively? Let's start with procedural fairness and the range.
Their reasoning on that crucial procedural fairness ground was absolutely key, and it really set the scene for the high court battle later. They firmly rejected the argument. They held that Justice King's refusal to hear the range submission was not a denial of procedural fairness. In fact, they said it was immaterial to the sentencing process.
Immaterial? Why? That seems counterintuitive if it influenced the plea.
Their reasoning was this. Identifying the proper sentence, the legally appropriate sentence, is exclusively the job of the judge. It's a core judicial function. A prosecutor's opinion on a numerical range they held is just that, an opinion. It has no binding legal force on the judge whatsoever.
So the judge wasn't required to listen to an opinion?
Essentially, yes. They actually cited the existing Victorian practice that had developed under previous case law, particularly a case called R.V. McNeill Brown.
What does McNeill Brown say?
It established a sort of rule in Victoria at the time. It said that a prosecutor's duty to assist the court on sentence only really extends to providing a range if the judge specifically asks for that kind of assistance, or if the prosecutor genuinely perceives a real risk of sentencing error based on something the judge has said or indicated.
Okay.
So the Court of Appeal applied that here. They said since Justice King hadn't asked for assistance with a range, and since, in their view, she hadn't indicated she was about to make some obvious error, her refusal to hear the Crown's range was perfectly appropriate under the McNeill Brown practice and caused no actual unfairness to the accused.
Interesting. So they upheld the Victorian practice at that point. What about the manifest excess ground? Were the sentences just too long?
The Court of Appeal also held the sentences were not manifestly excessive. They acknowledged the sentences were extremely severe, particularly Barbaro's life term. But they found the severity was fully justified by the uniquely egregious nature of the crimes and the extremely high level of culpability demonstrated by both men, especially Barbaro as the apex.
Did they address the crushing aspect?
Yes, they basically echoed Justice King's point. They stated that offenders like these, involved in crime on such a massive scale and with such gravity, had effectively forfeited their right to leniency or any expectation of getting out easily within their natural lifespans. President Maxwell even noted explicitly that some crimes are just so serious they justify leaving an offender with little hope of freedom, and this case fell squarely into that category.
Strong stuff again. Did they mention anything else on that point?
Yes, quite significantly, they highlighted that Barbaro's own counsel, Mr. Priest QC at the time, had actually conceded during the sentencing plea hearing that his client expected a significant jail sentence with no real prospect of much life after release.
Oh, really? That seems to undercut the appeal argument somewhat.
It definitely undermined the argument that the sentence ultimately imposed was somehow unexpectedly crushing or so excessive as to constitute a legal error when his own lawyer had foreshadowed such a grim outlook.
Okay. And Zirilli's sentence, the 26 years.
Also upheld. The court acknowledged he was subordinate to Barbaro, but they stressed the sheer scale of the overall operation, and his crucial coordinating role still warranted a very heavy penalty, despite his slightly lesser position in the hierarchy.
What about Zirilli's specific point about remorse? Did the court address that?
They did. They found no error in Justice King's approach to assessing remorse. In fact, they described her assessment as impeccable.
Impeccable. High praise.
Yes. They were careful to draw a distinction, as judges often do, between the anguish of being caught, feeling sorry for yourself, and genuine remorse for the actual harm caused by your actions. They even referred to dictionary definitions to support this distinction.
And the guilty plea.
The Court of Appeal agreed with Justice King that the utilitarian value of the plea saving the trial was recognized and factored into the sentence, most obviously in Barbaro not getting life without parole. But they found no specific error in how she assessed the genuineness of remorse beyond that practical benefit. So Zirilli's ground on remorse also failed.
So a complete wipeout at the Court of Appeal, leave refused on all grounds. The crushing sentences stood.
Correct. But the legal teams, particularly given the fundamental disagreement about the role of sentencing ranges and procedural fairness, were determined to take one last shot.
The final stand. The High Court of Australia.
Exactly, the highest court in the land. A successful appeal here wouldn't just affect Barbaro and Zirilli. It would set a precedent for the entire country. The case reached the High Court, ensuring its eventual ruling would have truly national significance.
Who was on the bench for this final hearing?
A panel of 5 justices: Chief Justice French, Justice Hayne, Justice Kiefel, who later became Chief Justice, Justice Bell, and Justice Gageler, a very senior bench.
And the legal teams. We mentioned some changes earlier.
Yes, significant changes in senior counsel for the appellants. For Pasquale Barbaro, Stephen J. Odgers, SC, took over from Philip Priest, QC, as senior counsel. Theo Casamatis remained as junior counsel, instructed by Theo Magazis and associates.
Okay, Odgers SC is a big name in criminal law. And for Zirilli,
L.C. Carter replaced Michael Croucher, SC, as senior counsel. But F.H. Todd, Francis Todd, remained as junior counsel, providing that continuity from the very beginning, instructed still by Okoro & Co.
And the Crown, the respondent.
Represented by R.J. Bromwich, SC, who later became a federal court judge, and B.M. Young, SC, who was the trial prosecutor, instructed by the Commonwealth DPP's Melbourne office.
And we mentioned the Victorian DPP intervened. Why was that so important?
Hugely important. The Director of Public Prosecutions for Victoria saw it and was granted leave to intervene. They were represented by Gavin J.C. Silbert, SC, the Chief Crown Prosecutor for Victoria at the time, and B.L. Sonnet.
Why did the Victorian State Prosecutor get involved in a Commonwealth case appeal?
Because the case had massive implications for the distinct sentencing range practice that had become entrenched specifically in Victoria. The McNeil-Brown practice the Court of Appeal had just upheld. The appellants were challenging this practice.
So the Victorian DPP intervened too.
To argue against their own state's established practice. They submitted to the High Court that the Victorian practice of prosecutors providing numerical ranges was actually wrong in principle and should stop.
Wow, that's unusual. A state body arguing its own long-standing practice is wrong.
It really highlights how significant they thought the issue was for the proper administration of justice and the integrity of sentencing across the board. They wanted the High Court to rule on it definitively.
Okay, so what were the core arguments put to the High Court? Still focusing on the range and sentence length?
Pretty much, yes, but argued at the highest level of legal principle. The core issues remain procedural fairness, the refusal to hear the range submission, and manifest excess, the sentences being too long. Zirilli's team also kept pursuing the remorse point.
What was the appellant's main line on procedural fairness this time? Barbaro and Zirilli's argument.
They focused heavily on it. They argued forcefully that the Crown's indicated range in that plea offer letter should have been heard and properly considered by Justice King. They framed it as effectively a concession by the Crown on the appropriate ballpark figure, a concession that had heavily influenced their client's decisions to plead guilty. They felt the refusal denied them a reasonable opportunity to fully present their case on sentence.
Did they try to elevate the status of the range submission itself?
Yes. They argued it wasn't just a mere opinion. They tried to argue it was actually a submission of law.
How so?
By arguing it related to the bounds of what would constitute an appealable error in sentencing, defining a sort of House v. the King range that's a foundational high court case about when appeal courts can interfere with sentencing discretion. They were trying to give the range more legal weight.
And they argued the Victorian practice created an expectation.
Exactly. They argued the established McNeil-Brown practice created a reasonable expectation that the judge would at least be informed of the Crown's range, even if she wasn't legally bound by it. And they felt she should have given it serious consideration before imposing sentences that were, in their view, significantly higher.
Did they raise any other points, like reasons for sentence?
Yes. For Barbaro specifically, they argued Justice King gave no adequate reasons for picking the 30-year non-parole period. Her only stated reason was essentially that The plea prevented life from meaning life without parole, which they argued wasn't sufficient justification for such a long minimum term.
Okay. And the Crown, the respondent, how did they counter these arguments?
They counter-argued vigorously on all points. On the range issue, they maintained there was no actual agreement for the Crown to make a formal range submission if the judge didn't require it. That letter, they said, was just an indication of their position at that time during negotiations. It wasn't a binding agreement or a concession of law about the legally correct range.
So the judge refusing to hear an opinion wasn't an error.
That was their argument. Justice King's refusal to hear what was merely an opinion wasn't a procedural error. They submitted that a Crown range is simply an opinion, and its significance should not be exaggerated. It doesn't define the legally permissible sentencing range.
Did they argue the range wouldn't have mattered anyway?
Yes. They pointed to Justice King's detailed sentencing remarks, arguing they showed a careful and proper approach consistent with high court sentencing principles, like those in Highland-Jones, and they argued the extreme seriousness of the offending was such that the Crown range, even if Justice King had heard it, could not have made a difference to the outcome because the very high sentences she imposed were entirely justified on the facts.
Okay. Now, the Victorian DPP, the intervener, their argument against their own state's practice must have been powerful.
It was arguably the most legally significant submission for future practice across Australia. They argued, point blank, that the Victorian practice originating back in R.V. Casey and Wells in 1993 and affirmed in McNeil Brown, where prosecutors voluntarily provide numerical sentencing ranges, is fundamentally wrong in principle and should stop. Everywhere.
What were their reasons for saying it was wrong?
They laid out several key arguments. First, they contended that the prosecutor's general duty to assist the court does not extend to suggesting a specific number of years.
Why not?
Because, they argued, this practice effectively usurps the role of judges, who have the sole responsibility for determining the appropriate sentence based on all the evidence and legal principles. It muddies the water about who is actually doing the sentencing.
What else?
They argued it's inconsistent with the accepted method of sentencing in Australia, known as instinctive synthesis. That's where judges are supposed to weigh up all the relevant factors holistically to arrive at a single, just sentence, rather than starting with some predetermined numerical bracket suggested by the prosecution.
Any other points?
Yes. They also argued the practice often relied on potentially irrelevant comparison cases, lacked proper legal authority, and critically carried a significant risk. The risk was that judges might feel subtle pressure to sentence within the range suggested by the Crown, perhaps just to avoid the hassle of a potential appeal, rather than exercising their own independent judgment. They even cited observations from other cases like LJVR, hinting at this risk.
And they contrasted Victoria with other states.
Yes. They pointed out that in most other Australian states and territories, this kind of numerical range submission by prosecutors wasn't common practice anyway. Their core submission was that the prosecutor's duty should be limited to assisting with relevant facts, legal principles, and genuinely comparable appellate court decisions that discuss general sentencing approaches for certain types of offenses, but definitely not suggesting a specific number of years.
So, a very comprehensive argument against the practice. The stage was set for a landmark ruling. When did the High Court hand down its decision?
February 12, 2014. The High Court delivered its judgment, and the outcome for Barbaro and Zirilli themselves.
Unanimous dismissal. Both appeals were dismissed. Barbaro's life sentence with a 30-year non-parole period and Zirilli's 26-year sentence with an 18-year non-parole period were upheld. They stood.
The end of the road for them personally. But, as everyone expected, the real significance of the ruling went far, far beyond the fate of these two men. The landmark majority reasoning, delivered jointly by Chief Justice French and Justices Hayne, Kiefel, and Bell, fundamentally and permanently reshaped criminal sentencing practice right across Australia.
What was the core ruling? The big takeaway?
They held, with absolute clarity and undeniable force, that prosecutors should not make submissions on available sentencing ranges, full stop.
So no more suggesting numbers.
Exactly. That practice, particularly the routine way it had developed and been applied in Victoria, was explicitly declared wrong in principle and should cease.
So they directly endorsed Justice King's approach back in the original sentencing.
Absolutely. They completely vindicated her refusal to hear the range. The majority's reasoning was grounded in that fundamental separation of roles in the courtroom.
Explain that reasoning again.
They reasoned that identifying the appropriate scope of a lawful sentence, figuring out the right punishment, is inherent to the judge's exclusive sentencing function, It's not some separate legal principle, and it's certainly not a matter for adversarial debate where the parties haggle over numerical parameters.
So a prosecutor's range suggestion is just.
No more than a statement of opinion. That's the key phrase from the judgment. It lacks any authoritative legal force or basis in the actual law of sentencing itself. Therefore, a sentencing judge is not obliged in any way to entertain or consider a prosecutor's opinion on range. And refusing to do so, as Justice King had done, is absolutely not a denial of procedural fairness to the accused. The High Court could not have been clearer.
What about Justice Gageler? He agreed with the outcome, but had a slightly different take.
Yes, he wrote a separate concurring opinion. He agreed entirely with the result. The appeal should be dismissed. No miscarriage of justice had occurred. The sentences should stand.
But he disagreed on
one subtle legal point: whether a numerical range submission could ever, theoretically, be characterized as a submission of law. The majority said no, it's just opinion. Gageler thought, well, maybe it could be seen as a submission of law because it relates to the perceived outer bounds of a lawful sentence and connects to those principles of appellate review under House v. the King.
But did that difference matter in the end?
Not for this case. Because even accepting that possibility that it might be a submission of law, Justice Gageler ultimately concluded that in this specific case, there was no actual unfairness or loss of opportunity to the defense that would justify overturning the sentences anyway.
So bottom line, all 5 justices agreed.
Yes. While they differed slightly on the precise legal nature of a range submission, all 5 justices agreed that Barbaro and Zirilli had received fair hearings, that their sentences were not manifestly excessive given the sheer gravity of their crimes, and most importantly for future legal practice, that sentencing judges are simply not obliged to hear or consider numerical sentencing ranges proposed by the prosecution.
The sentences were upheld, and the door was slammed shut definitively on the era of prosecutors voluntarily offering numerical sentencing ranges.
A truly landmark decision, born from a case involving tomato tins full of ecstasy.
Incredible. So let's pivot now to the aftermath. What does this whole dramatic saga, Barbaro and Zirilli, the canned tomatoes, the refused range, the High Court ruling, what does it all mean for you, listening now perhaps as an aspiring barrister, trying to navigate the complex, often difficult world of criminal law?
Well, the implications are profound, and this case really does serve as a foundational cautionary tale. You ignore its lessons at your peril, frankly.
What's the single biggest, most tangible impact?
It's got to be the virtual end of numerical Crown sentencing ranges being voluntarily offered by prosecutors during sentencing hearings right across Australia. The High Court's directive in Barbaro was so clear, so unambiguous, it effectively abolished the practice that had been common, particularly in Victoria, and it reinforced the position in other states and territories where it wasn't standard anyway.
So what can a Crown prosecutor do now at sentencing? What's their role in assisting the judge post-Barbaro?
Their duty now is understood differently. They assist the court by outlining the agreed facts of the case, highlighting the aggravating factors supported by evidence, acknowledging relevant mitigating factors, referring to the specific sentencing legislation, and importantly, drawing the court's attention to genuinely comparable appellate court decisions.
Decisions that discuss sentencing principles or general approaches for similar types of cases.
Exactly. But what they absolutely do not do is suggest a specific numerical range of years, like we say the range is 5 to 7 years. That's gone. This reinforces the independent role of the judiciary. The judge alone determines the sentence.
What if a judge asks the prosecutor for a range now? Can that happen?
It's less likely, but possible. Right. And post-Barbaro, the general advice to prosecutors, based directly on the High Court's reasoning, is to respectfully decline that invitation. The High Court pretty clearly implied that judges shouldn't be asking for numerical suggestions from the parties anyway. It's the judge's job, their function alone.
Okay, that's the impact on prosecutors. What about for defense barristers? This is where the cautionary tale really bites, isn't it?
Oh, absolutely. For defense lawyers, this case serves as an incredibly stark reminder about the fundamental, sometimes brutal, limits of plea negotiations.
Explain that. Plea deals are still vital, right?
Yes, absolutely. Plea agreements remain a vital part of the criminal justice system. They offer substantial benefits, getting charges dropped, agreeing on favorable facts, saving the client the stress and risk of trial, potentially getting a discount on sentence. But, and this is the huge Barbaro lesson, a plea agreement cannot guarantee a specific sentencing outcome.
Even if the prosecutor indicates a likely range, even in writing, like in Barbaro's case.
Even then. Any indication of a likely sentence given by the prosecution during negotiations, however specific it seems, is ultimately informal and not legally binding on the sentencing judge. The judge can always depart from it, sometimes drastically, as Justice King did here.
So, after Barbaro, what can prosecutors formally agree to regarding sentence and plea deals?
They are even more constrained now. They can still agree to withdraw certain charges. They can agree on a specific, perhaps more favorable set of facts to be put before the court. They might agree not to oppose a particular defense submission, like, say, on the client's role, or the need for a certain type of order.
But they can't promise a number.
Absolutely not. They cannot promise to advocate for or agree with a specific number or range of years imprisonment. That's off the table thanks to Barbaro.
This puts a huge ethical weight on defense barristers, doesn't it, in terms of managing client expectations?
A massive onus. It falls squarely on the barrister for client management and ethical duty. You absolutely cannot promise your client a particular sentence based on some indication you receive from the prosecution during negotiations. It's just not a promise you can make.
So, what must you advise your client?
You must advise them honestly, clearly, and cautiously that the final sentence is solely at the judge's discretion, and that even if, hypothetically, you and the prosecutor were to make a joint submission agreeing on a number, a practice now largely stopped by Barbaro anyway, the judge is still not bound by it.
That must lead to some incredibly difficult conversations, especially if the client feels a promise was broken, even if it was just an informal nod from the prosecutor.
Exactly. And clients often do feel that way. Barbaro just highlights the vital importance of providing crystal clear, maybe even brutally honest advice from the very outset about the inherent uncertainty of sentencing. You have to manage expectations about the judge's ultimate power.
Okay. What about for the Crown prosecutors themselves? Does Barbaro change their ethical perspective?
It reinforces their primary ethical duty, which is not just to get a conviction or the highest sentence, but their paramount duty to the court and the administration of justice. By removing the practice of volunteering numerical ranges, the High Court aimed to reduce any lingering perception that sentencing outcomes might be influenced by backroom deals or negotiation tactics.
So the focus shifts.
Yes, squarely back to the prosecutor's role as a minister of justice. Their job is to fairly present the case, the relevant law, the applicable principles, the precedent, not to act purely as an adversary pushing for a specific number, and certainly not to appear to be usurping the sentencing role that belongs solely and completely to the judge.
The case also seems to offer a lesson about courtroom behavior, maybe, particularly for defense lawyers.
Yes, definitely a lesson on the limits on advocacy and courtroom decorum. Barbaro starkly illustrates the need to respect the judge's procedural rulings, even if you strongly disagree with them.
Like Zirilli's counsel initially trying to push the range submission against Justice King's clear direction.
Exactly. While you absolutely have a right, and often a duty, to object to a ruling to preserve your client's position for potential appeal, you need to get it on the record. Insisting on making a submission against a clear, repeated judicial instruction can be counterproductive. It risks irritating the bench, potentially to your client's detriment. It's a fine line to walk.
So sometimes the fight has to wait for the appeal court.
Precisely. The battleground for challenging fundamental legal principles, like the role of sentencing ranges, or how plea negotiations should be treated by judges, might need to shift strategically to the appellate courts after the sentencing is done, rather than being fought out head-to-head with the trial judge against their clear ruling on court procedure.
Finally, does the Barbaro ruling help with sentencing consistency and transparency? Was that part of the goal?
Theoretically, yes. That's the argument. By reinforcing the principle of instinctive synthesis, that holistic weighing of factors by the judge, the ruling aims to promote transparency. By requiring judges to articulate their reasons for the sentence, based explicitly on established legal principles, relevant precedent, especially appeal court decisions, and the specific unique circumstances of the case before them, rather than potentially just starting with or endorsing a possibly arbitrary number that might have come out of negotiations.
So the reasoning becomes clearer.
That's the idea. It should make the process more transparent and subject to clearer appellate review, because the review court can see why the judge reached that particular sentence based on articulated principles.
And consistency comes from?
Consistency, post-Barbaro, is understood primarily as applying the same legal principles consistently to similar factual situations. It doesn't necessarily mean arriving at the exact same numerical result every single time, because every case has unique nuances.
So for barristers making sentencing submissions now,
The focus needs to be intently on those core legal principles: proportionality, deterrence, general and specific, rehabilitation prospects, parity with co-offenders, denunciation of the conduct, mercy where appropriate, and drawing persuasive factual analogies from comparable appellate decisions. It's about the principles and the facts, not haggling over numbers with the prosecutor or trying to pin the judge to a pre-agreed figure.
So, in essence, Barbaro was a powerful restatement by the High Court.
Absolutely. A powerful restatement that the barrister's job at sentencing, whether for Crown or defense, is fundamentally to assist the court in its incredibly difficult independent task, the task of determining a just punishment based on law and facts. It's not about trying to sentence for the judge or predetermine the outcome based on deals made outside the courtroom.
Okay, let's try and wrap this up. It's been a fascinating journey. So to recap this truly dramatic legal saga, it started with that unbelievable Ecstasy bust, the biggest in Australian history at the time, hidden in those everyday tomato tins. Then came the guilty pleas, heavily influenced by a sentencing range indicated by the prosecution in a letter.
Which was then completely sidelined by the sentencing judge, Justice King, who refused point-blank to even hear submissions on it.
Leading to crushing sentences life, with 30 years non-parole for Barbaro, 26 with 18 for Zirilli. Sentences upheld by the Court of Appeal.
And finally, the High Court of Australia. While upholding the sentences, they delivered that landmark decision, a decision that fundamentally changed the rules of sentencing practice, declaring prosecution submissions on numerical ranges wrong in principle, and delivering this foundational cautionary tale for barristers right across the country. That reliance placed on a suggested range during plea talks, it proved utterly futile against the judge's ultimate independence and the High Court's powerful pronouncement.
So the core lesson for you, listening now, especially if you're heading towards a career at the bar, seems crystal clear. While plea negotiations are absolutely a vital skill, a vital tool in your toolkit,
you must understand their absolute limits when it comes to the sentence itself. The judge, and only the judge, holds the ultimate power in determining that sentence. They are bound only by the law and the facts before them, not by any agreement the parties might have reached on a number.
manage your client's expectations with unwavering honesty, with caution, right from the very beginning.
Absolutely critical. And focus your advocacy in court, not on trying to hold the crown to some number mentioned in negotiations, not on haggling over years like it's a market stall, but on truly assisting the court. Persuasively presenting the facts, arguing for a just outcome based fair and square on the established legal principles of sentencing and the unique specific circumstances of your client and their case.
It really reinforces the barrister's duty to the court above all else.
It does. And building on everything we've explored today, perhaps consider this final provocative thought, something that continues to shape legal practice and debate. Did the High Court, by removing the Crown's ability to suggest a numerical range, truly enhance justice? Did it purify sentencing, making it solely a judicial function untainted by negotiation tactics?
Or is there another side?
Or did it, perhaps unintentionally, remove a potentially valuable source of information? Information that might have helped guide judicial discretion, maybe provided a check, maybe brought some element of predictability to an inherently uncertain process. Did Barbaro, in aiming for principled purity, potentially make the sentencing process less transparent and predictable for everyone involved, including you, the future lawyer, trying desperately, ethically to advise your client on what they might realistically expect?
That's a really tough question.
It is, and it's a question that barristers, prosecutors, and judges grapple with, implicitly or explicitly, in courtrooms and chambers every single day since Barbaro v. the Queen.